Call this meeting of the House Commerce Committee to order. We do have a quorum present. The first item of business is approval of our minutes from April 17th, 2024. Representative Katiza-Wattoon, do you want to make a motion?
Mr. Chair, I would move approval of those minutes.
Representative Katiza-Wattoon moves approval of the minutes from April 17th, 2024. Any discussion to the motion? Seeing no discussion, all those in favor say aye. Aye. Opposed? Motion prevails. Minutes are approved. The next item of our business is House File 5363 from Representative Frazier. I will move House File 5363 be re-referred to the Committee on Ways and Means. I will also move your A8 Authors Amendment, which Representative Frazier gets the bill in the shape you'd like us to consider it. Yes?
That's right, Mr. Chair.
All right. Any discussion to the A8? Seeing no discussion, all those in favor say aye. Aye. Opposed? Motion prevails, and the A8 is adopted. Representative Frazier, to your bill as amended.
Thank you, Mr. Chair. And I'll just describe what the A8 amendment is before we get into the discussion around the bill. The A8 amendment provides clarifying language around the first qualifying week, clarifying that week is eligible for payment, and then it also provides language that addresses intermittent leave, a cap on intermittent leave for 480 hours. To the bill. So last year, just want to remind folks, we did a really great thing. It's a big deal. We created a paid leave program to join 13 other states in the District of Columbia in our country, but also to join other industrialized countries around the world that provide for an opportunity for folks to have paid leave if they need it and when they need it, so that they don't go into financial ruin when they need to take care of themselves or family members. The bill that I am carrying this year is mainly technical fixes to ensure that the program runs effectively, smoothly, and efficiently. And much of the information is, this is an agency bill, so it's feedback from the agency, recommendations from the agency, and the agency does have a director now that comes from the state of Massachusetts that has a program in place before ours, and so this is largely good feedback, good input, good recommendations, and trying to move it through the process so we can make sure we have things set to go. And Mr. Chair, I do have the Deputy Commissioner here from DEED as a testifier, and if you will oblige, he will be sitting here with me to help address questions.
Sounds great. All right. Are there any members of the public who wish to testify as to this bill? Seeing none, we'll move to member discussion to the bill. Discussion to the bill. Representative Brindley.
Thank you, Mr. Chair, and Representative Frazier. I know in this new language, former employees are required to be covered for 26 weeks or until they are hired by a new employer. Does that include voluntary separation, or is it solely for employees who have been laid off or terminated?
Representative Frazier.
Good morning, Representative Brindley. It's been a while.
It has.
Mr. Chair, I am going to kick that over to Deputy Commissioner Rowe here.
Deputy Commissioner, if you could state your name for the record and then answer Representative Brindley's question.
Thank you, Mr. Chair. For the record, my name is Evan Rowe, Deputy Commissioner of the Department of Employment and Economic Development, and I think the language in the bill is separated. The language is separated. It doesn't have a specification regarding termination or quit or.
Representative Brindley.
Thank you, Mr. Chair. So just to follow up on that, so I want to be very clear, because this is, I think, an important detail. So if someone chooses to leave their employment, not at the fault of the employer is still on the hook for 26 weeks, regardless of the fact that it is actually the employee who chose to leave. The employer is still on the hook for 26 weeks.
Deputy Commissioner.
Thank you, Mr. Chair, Representative. I would just say that this is not the same program as the unemployment insurance program, right? Which is more focused on discharges, quits, and those kinds of elements. This is a program primarily focused on or entirely focused on paid leave for family or medical reasons. So the department is not adjudicating the reason for not being employed under the law.
Representative Brindley.
Thank you, Mr. Chair. I appreciate that that clarification. However, it is still a program that employers are required to pay a tax on for each employee, and so if they are still on the hook for that, they are paying for an employee who chose to leave them voluntarily. presumably they would still have to pay the tax on that employee if they have chosen to voluntarily separate. How would that function?
Deputy Commissioner.
Thank you, Mr. Chair, Representative. So again, I think there is a notable difference between this program and the unemployment insurance program in the sense that, in the unemployment insurance program, individuals layoffs can impact an employer's premium rate in the future. In the paid leave program, an employer only pays premiums while the employee is employed. You're only paying on the wages that are actually being paid to the employee. So I think an alternative kind of viewing of this provision is that the employer and the employee have paid into the program, and a former employee would be receiving benefits that they have already paid for as part of the premiums that have been collected as part of this program overall.
Representative Brindley.
Thank you, Mr. Chair. So that is interesting. So my question then would be, if no one is contributing the tax during the lengthy periods of time that folks are allowed to participate in paid family leave in the state, won't every other taxpayer be required at some point to increase those taxes? I mean, that's what we've seen in every other state, right? We start with these low taxes and we end up having to increase the tax to make these programs solvent. How does this program remain solvent if the folks who are receiving the benefit are not participating?
Deputy Commissioner.
Thank you, Mr. Chair. Representative, I would disagree with the characterization regarding every other state. But aside from that point, your benefit in part is based on the premiums that you're paying. Additionally, I think as we've worked with independent actuaries to model the impact of the program, that is a known factor that has gone into the actuarial modeling. That would be that is factored in as one considers the impact of the program overall.
Okay, last point.
One more, Representative Brindley.
Thank you, Mr. Chair. My last point I will make then is I hope that the majority then also sees the sort of injustice in taxing the Social Security benefit. If we're not taxing this benefit, we shouldn't be taxing that benefit either. Folks have already paid their taxes to receive that benefit. Thank you, Mr. Chair.
Representative Perryman.
Thank you, Chair. Rep. Frazier. Speaking as a small business owner, I just have a couple of questions and concerns, and that is the November 15th due date that is in the bill, and for the new rates, it seems kind of difficult for a business owner to budget at that date. Is there a reason why you chose the November 15th date?
Representative Frazier.
Thank you, Mr. Chair. Representative Perry, good morning as well.
Good morning.
Yes, that date is being chosen because we are trying to line this up with the UI program that we have. That is the time frame that we provide formal information around those rate changes. What I will say, and we are having this conversation around language to address the very issue that you are raising. Multiple stakeholders have raised this issue. The information actually will be available, and I believe the first is probably January. It can be published, so we will have access to the data. It just won't be that formal letter saying that what the rate changes will be. And the reason we're trying to line it up is for efficiency and not redundancy. And so business owners such as yourself or other stakeholders like school districts, counties, don't have to look for multiple letters, but we are working with language to address that particular issue. And Mr. Rowe, if you'd like to add anything.
Representative Perryman.
Thank you, Chair. Thank you, Rep. Yes, if you could look at that date, some of my the cities, like the mayors, are concerned about all the work they've got to do, obviously workforce issues as well with that. So I'm just asking if you could take a look at that date. And then the other question, Chair, another question would be, my question is striking or not understanding the point about the enrollment of an employee, but the employer is not notified. Could you address that as well?
Representative Frazier.
Thank you, Mr. Chair. We will be addressing that as well. We're working on language to ensure that notification will be happening.
Representative Perryman.
One more?
Yeah.
The 7-day work notification, in some states, I guess, the first notification, they don't get paid for the first 7 days. But in this bill, will we be starting an employee on day one, or will there be a 7-day waiting period?
Representative Frazier.
Thank you, Mr. Chair, Representative Perry. There will be the waiting period.
Okay,
Representative Schultz.
Thank you, Mr. Chair.
and thank you.
Representative Frazier, well, actually, this is probably a better question for Deed. Last year, we transferred a significant amount of money. I believe it was, man, it looks like $668 million from the general fund to the Family and Medical Benefit Insurance account. It appears like that would have been for the startup cost, or I guess maybe the better question is, of that amount of money, how much of that is for startup costs versus running the program?
Representative Frazier.
Special good morning to you, Representative Schultz.
Thank you.
Thank you. So that is, in my understanding, I will let the Deputy Commissioner jump in here, but we put that money there. We had the benefit of seeing what other states did and how they started their programs. And based on the way those states started their programs, we wanted to ensure that this program would have the best start, would have the best, be resourced and ready to go when it goes into effect on January 2026. So that money is there to ensure that it's ready to go at that moment. But I will also defer to Deputy Commissioner here.
Deputy Commissioner.
Thank you, Mr. Chair, Representative. I do not have I don't have last year's fiscal note right in front of me. I think, but broadly, I can kind of speak in general terms. I think the intention was that about 6 months of premiums under the program was part of that appropriation, as well as the startup costs required to set up the program there. So I think the objective, the lion's share, by a substantial margin, is kind of the first 6 months of premiums to fill up the fund to make sure that it's operating at a sustainable and safe reserve, and then any required implementation costs.
Representative Schultz.
Thank you, Mr. Chair. Yeah, I appreciate the information. I'm glad to hear that that's going to cover, the first 6 months. Do you have an idea, even a rough number for us this morning, of how much of that money has already been used?
Deputy Commissioner.
Mr. Chair, Representative, I would say that it is I would just say relatively little, just in the sense that we're still in the early days of the program, and we're trying to be very thoughtful and conservative in terms of how we're spending the money. Obviously, that's been entrusted to us to implement the program.
Representative Schultz.
Thank you, Mr. Chair. And if you're able to follow up, Mr. Commissioner, I think that would be helpful for us to just have an idea of how much has been spent so far. Realize that, this is fully enacted into law, but really curious as to where that status is right now, and would love to have that information if you could provide that. And then comparatively to other states, how long did it take them to set up their program, and are we on track compared to the other 13 states on the startup of our program?
Deputy Commissioner.
Mr. Chair, Representative, I think we are very much on track in terms of the implementation. As you might know, the go live date for program benefits to be paid is January 1, 2026. The timelines established under the law are, I would say, kind of right in the median of what other states have done. I think that we are, as we presented in House Workforce earlier, I think we are, doing everything that we can to leverage best practices from other states. We're leveraging best practices from within our own state, including the unemployment insurance division, and working hard to make sure that we are doing what works and discarding what doesn't. So I think we are very confident about the status of the program, the implementation date, the January 1, 2026 go live for the program, and we're really excited to deliver it for Minnesotans.
Representative O'Driscoll.
Thank you, Mr. Chair. Couple of things. Can Deed or the bill author remind myself and the committee, how long does one have to be employed in order to be eligible for a 26-week benefit? And I'll give you the second part of that, the question with this, the first part. So if because an employee can go back and claim with a previous employer the 26 weeks now of benefit, I want to kind of take a look at the fact that if someone's there, well, I'll just wait for the answer to see, and then we'll see, because I may not have to go further on that question. So again, the question is, how long does one need to be employed to be able to be eligible for going back to a previous employer to be entitled to that 26-week benefit?
Deputy Commissioner.
Mr. Chair and Representative, I want to first, if I might clarify something, there is not a 26-week benefit as part of this amendment, or as part of the bill. What the bill is clarifying is the treatment of former employees for private plans. The duration of the benefit is still 12 weeks for any individual type of leave, up to a combined cap of 20 weeks, same as it was when the law, under the law right now. The eligibility criteria are there are a few different points, but I guess I'd refer you to just from memory 268B.07 subdivision 1, which delineates I'm sorry, 268B.06 subdivision 1, which delineates the eligibility conditions. The eligibility conditions are, first, that the individual must be unable to work due to a serious health condition in the case of medical leave, the birth or adoption or fostering of a child in the case of parental leave, need to care for a loved one who is undergoing a serious health condition of their own under the provision of family leave, supporting a family member who is about to undergo active deployment for qualifying exigency or military leave, or facing a significant personal safety issue or domestic violence issue in the case of safety leave. That is the first criterion. The second criterion is that they have to have sufficient wage credits established under the law, and that definition is 5.3% of the state's average annual wage. And then they have to, of course, demonstrate and to prove that eligibility for those specific elements of that I previously delineated. They have to have a qualified professional provide the certification thereof.
Representative Driscoll.
Thank you, Mr. Chair, and to the Deputy Commissioner. I think we were getting close to what my question was on your final comment. Can you review for the committee and the benefit of the public that's here today as well, what the criteria is to earn the credits then to get to a 12 or 20 week? My apologies for the 26 weeks. I'm trying to find out, is there a situation where the plan will be having additional unfunded liabilities built in because someone would maybe work for 30 days and be eligible for 3 weeks of benefits retroactively coming back, where there would clearly not have been enough money put in by the employer or employer and employee combination to pay for that type of benefit for an individual retro claiming after departing employment?
Deputy Commissioner.
Thank you, Mr. Chair. Representative, I guess I would, to the question again, the financial criterion is that the applicant has sufficient wage credits, which under the law is defined as 5.3% of the state's average annual wage. I guess what I would say is, like most social insurance programs, it is not, it isn't inherently tied one to one, it is not tied dollar for dollar. You pay in what you pay out. It is a pool, it is a risk pool, and that is kind of the benefit of a social insurance model. So over time, I think over time, one's contributions, in any social insurance program tend to equalize out. Naturally, though, if one has a medical crisis in a particular year, you may be getting more in benefits for that particular year than you put in. But over time, like all social insurance programs, it tends to even out. That is the benefit of a large risk pool. That is the benefit of the model that is here under the law.
Representative Driscoll.
Thank you, Mr. Chair. Well, again, I'm not going to ask a third time for an explanation about how the accrual of benefits work on here. We're just going to have to go back to the state statute and take a look at that ourselves. And I suspect that there's going to be an inherent built-in unfunded liability on this. The second question that I have, or area that I'd like to visit with, is this idea of the elimination period. And that's what you referred to as the waiting period. It's officially referred to in the industry as an elimination period. It's a deductible in time versus a deductible in dollars. And the bill has two different sections, and they're the public section and the private employer section. And there seems to be a conflict as to whether or not there is an elimination period. Is that going to, well, one has the elimination period, the other doesn't right now. Will that be synced up so that both public and private institutions and organizations will enjoy the same benefit of an elimination period?
Deputy Commissioner.
Mr. Chair, I guess I would just, could I just ask to clarify which piece of the language you're saying is out of sync?
Representative Driscoll.
Thank you. In the private plan, it talks about the fact that they are required to have no elimination period, but government entities and government agencies can require an elimination period before benefits begin, is my understanding. My apologies, things are moving very fast. We got the author's amendment last night, very late. Trying to get my team together in this breakneck pace that we're working at here toward the end of session. Busy with my folks, that's why we're a little bit late this morning. So we're trying our best to do the work of the public here. So that is my understanding, and I'm hoping that you can also help me as the expert who's most familiar with this in the state of Minnesota, sir.
Deputy Commissioner.
Thank you, Mr. Chair. And Representative, I mean, I guess perhaps maybe we could have a follow-up on this, because that's not my I guess that is, I think the intent is that there is a level, that there's a level playing field between the state plan and private plans. So if there is a statutory site that you're pointing to, I'd be very happy to have that conversation. But I guess it's a little hard to answer the question absent the citation.
Thank you, Mr. Chair. The other problem concern that I have, and I brought this up last year, and we were able to get an actuarial study done to find out, do grossly the numbers work in and the dollars in, dollars out, anticipated use, and we found out that we were underfunded. Now we're going to be changing some of the benefit set a little bit again here, and the term was used clarifying that someone could go back and claim benefits from a previous employment situation. I suspect that the program is not going to have the ability to be able to, as you mentioned, Deputy Commissioner, kind of even out over time. I think what you're going to see is that the program is going to continue to have dollars out, run a deficit, and we're not going to be able to catch up with that. So that's more of a statement on here. My overall concern is that we haven't really improved the program as much as we have expanded benefits under the program without really looking at the big picture of what the costs of this plan are going to be. And I want to thank Representative Perryman for bringing forward our local units of government and the requirements that they have for levies. Mr. Chair, I would be willing to bet that as I look around here, there's not too many people in this room who can tell me the date that the cities have to have their preliminary levies approved. I can from my involvement in local government. I know that there's a few others. And that is they have to have that approved by mid-August of the year prior to. So the statement that was made that, well, those numbers will be ready by November 1st, but there'll be some preliminary numbers available in January, really doesn't help a local unit of government, particularly if they're a smaller city or school district, and being able to budget for that. Once a preliminary levy has been set, it can be reduced, but it cannot be increased. So those are mandatory burdens that are placed on that local unit of government that will compromise services if they have to pay these mandated fees, whatever those may end up being, and not be able to provide services to a community. They may end up having to have layoffs, and those layoffs are involuntary. Those individuals could come back and claim on a plan as a previous employer and further put pressure on the system. Mr. Chair, I recommend that we lay this bill over and that we take serious consideration on addressing those issues. Thank you, Mr. Chair.
Thank you. Representative Frazier, closing comments?
Thank you, Mr. Chair. Just I would like to respond a bit to Mr. Representative O'Driscoll. Good morning, because I said good morning, everybody. Some assumptions were made. I am a former city council member. That's why I'm reacting to those stakeholders that have asked about the date. Representative Perryman, that's how I know that's an issue. I did know that date around the levy. We understand that. When I said that the data will be ready, we don't anticipate that data to vary much from when it's ready in January. So we'll be able to have the data before that date that they need it. It'll be able to be published. We'll be able to give it to them. They'll be able to see it so they can make those determinations based on that. We're really just trying to line this thing up for efficiency. That's why we picked the November date to line up with UI. It is in no way meant to be harmful to the stakeholders that will need this information. So we will address that issue. But thank you for raising it another time. Mr. Chair, it's a good bill. I think we need to focus on how good of a bill this is and how great it's going to be for Minnesotans, and not look for ways to disparage the bill or to think in a way that folks are going to try to take advantage of it. So I'm looking forward to continuing to move forward and having it ready to go in 2026.
All right. Pursuant to House Rule 10.05, Representative Cagle and Representative Tabke are remote voting in the hearing today, have been authorized by the Speaker to participate remotely. Therefore, we will take a roll call on the bill. I will renew my motion that House File 5363, as amended, be recommended to be re-referred to the Committee on Ways and Means. Mr. Durfee will take the roll. The chair votes aye.
Chair Stevenson, aye. Vice Chair Cortez-Wattoon. Aye. Cortez-Wattoon, aye. Lead O'Driscoll.
O'Driscoll, no.
O'Driscoll, no. Representative Bierman.
Bierman, aye.
Bierman, aye. Representative Cha, excused. Representative Dotseth.
Dotseth, no.
Dotseth, no. Representative Freiberg.
Yes.
Freiberg, aye. Representative Cleavorn.
Aye.
Cleavorn, aye. Representative Cagle.
Aye.
Cagle, aye. Representative Kraft.
Aye.
Kraft, aye. Representative Liebling.
Aye.
Liebling, aye. Representative New Brindley. New Brindley, no. Representative Niska.
No.
Niska, no. Representative Perryman.
No.
Perryman, no. Representative Farr.
Farr, no.
Farr, no. Representative Schultz.
Schultz, no.
Schultz, no. Representative Tabke.
Tabke, aye.
Tabke, aye.
There being 9 ayes and 7 nays, the motion prevails, and House File 5363, as amended, is recommended to be re-referred to the Committee on Ways and Means. There being no further business before the committee is adjourned.